always ask in the community. That's very important. To look at the reputation. Most lawyers, we live or die by reputation. So asking friends, asking family, for particular lawyers in your situation, one that can handle your case, is in most instances one of the best ways to get an excellent lawyer.
Now, and you also, now some people will go just to the yellow pages and say, hey, I want to just eeny, meeny, miny, mo, catch a lawyer by the toe and have that person represent them. How safe an avenue is that?
Well, Ben, I think that goes, very adverse to what you said. Every lawyer has a particular area. There are some that are generalists, but just for the most part, going through the yellow pages, and not to disparage anyone that uses yellow pages, is perfectly fine to use. But the client has to be informed, because if you're going through yellow pages, it's particularly like going through a minefield. You're not certain what you're going to wind up with. You're using a lot of your time and effort. You're calling people, and as you stated earlier, most lawyers are very competent, very diligent, and have the client's best interest in mind. So when you call them, they'll let you know if they can help you or not, or some may not.
Let me also suggest that one of the points you said, Professor Hemphill, is correct, and that is, if you have the reputation of the attorney, that's a good starting point. Don't just stop there, though. Trust your own sense. When you call that law office, if you can't talk to a lawyer, and all you're talking to is a legal assistant, and you really need representation, you need to think twice. Is this the relationship you want with the law firm? That is, that every time you call in, all you're going to get is a secretary or legal assistant and not actually get to talk to the lawyers. And some lawyers are too busy for your cases, and you should understand that. I can tell you that in my firm, if a person calls in, they initially are vetted by a legal assistant, and then the legal assistant brings that information to me, and I speak to the potential client. I think that you need to know you want to have a one-on-one relationship with your attorney that is reasonable to be expected. And don't you think that that's an appropriate approach? Don't you think, Professor Hemphill?
That's very appropriate. One of the biggest things that you find in the disciplinary section in the bar journals is a lack of communication. Quite often, clients will call in, they retain a lawyer, and they can never talk to them. Just had a class on Tuesday where I spoke to the students about, if a client calls in 75 times, do you have to take the call? Of course, it all depends on what the conversation is and what they're seeking, but communication is very important, and you should be able to start out with effective communication from the beginning to know if that lawyer is going to be a good fit for you.
Now, after you've called, you should know that everything that you share with the attorney is confidential. In fact, once my clients start talking confidential information over the telephone, I stop them and tell them to come into the office, simply because I don't want whatever they're telling me to be intercepted by some potential opponent. I've actually had people to try and intercept communications coming into and out of my office. But the point is this: if you are talking to an attorney, whatever you share with them, there are only two exceptions, I'll talk about those in just a second, are confidential. If you've murdered someone, this is going to sound harsh, but you've murdered someone, and you come in and talk to the lawyer and tell them, I killed this individual, and this is going to sound harsh, the lawyer must treat that communication as confidential. What the lawyer cannot do, what she cannot do, is participate in a crime or fraud. You can't come into the lawyer's office and say, look, I want to kill somebody. Will you hide that for me? Now, the lawyer cannot, and the lawyer must disclose to you, I'm sorry, I cannot participate in a crime. And if you say, I want to defraud someone, the lawyer must tell you, I'm sorry, I cannot hold that in confidence if you're trying to get me to help you perpetrate a fraud. Now, if you've committed a fraud and you're coming in to ask the lawyer to represent you on it, that's something wholly different. The point is, you cannot have the lawyer or ask the lawyer to assist you in the commission of a crime or fraud, and that happens. Let me give you an example. About 10 years ago, a gentleman walked in with a suitcase full of money. He opened it up and he said, "I need your help because this money may have come in to my possession through curious means." I remember his phrase. His phrase, it was curious means. I said, "Well, your curious means are too curious for me." The point is, he wanted to use my office to launder money. And as such, I had to reject the case, and we did. As tempting as it may be. I ultimately found out he did get a lawyer to represent him. They both are in the big house right now, the lawyer and the guy with the money. But the point is, lawyers cannot help you perpetrate a crime or engage in fraudulent conduct. But you can tell them if you've committed a crime, and they cannot disclose that information. That is confidential. Some people ask the question, well, can the lawyer tell his or her wife or spouse about the case? Professor Hemphill, can you tell the audience what can the lawyer go out and say, man, let me tell you what this person did?
Client confidence is absolute.
That's absolute. I want you to know it is absolute. And if there is a violation, if for some reason you saw the lawyer's wife at church and she's looking at you funny because you told the lawyer something, that is a violation if she knows your secrets that you shared with an attorney. Now, on the issue of conflicts, can a lawyer, Professor Hemphill, take a case against a former client, or can a lawyer take a conflicting position and represent another client against the client that he's signing up?
Generally, you would start out saying no, but there are exceptions in terms of if there are disclosures and there are waivers. If it's within the ability of the lawyer and it is not adverse to the former client or the client you represent. For instance, if you have, say, a matter dealing with company A, and then there's a matter with a competitor company B, but it's unrelated. So if one company is being sued for a personal injury matter, but company B needs representation on a transaction or a deal contract matter, as long as you have a waiver, it's perfectly fine.
And let me give another example. A husband and wife want a divorce, and both come into the lawyer's office and say, we want to get a divorce, and we want you, lawyer, to represent both of us in the divorce. Should an attorney accept the representation of both the husband and the wife in the divorce?
Generally, I would stay away from that, but you can do it if they both sign off on waivers. But often those lead to a lot of problems.
A lot of problems. I want to tell you, if a husband and wife walked into my office and said, we want you to represent both of us in a divorce, and I already know that they want to get rid of each other, that's almost inviting a problem. Because then when the wife wants the car and the husband wants the same car, how do you represent those two interests? It is that kind of situation where the lawyer cannot assume a conflict situation or represent a conflicting situation against the client. In fact, generally, I reject both clients and tell them, go away, I can't represent either one of you now that you've shared confidential information with me. Now, so we have confidentiality, the communications are actually protected, conflict avoidance, and then you brought up, Professor Hemphill, competence. That the lawyer is competent in a particular area. And let's talk about competence just for a moment, and then we're going to talk about firing, because Showbiz asked the question, can you fire a lawyer and still have to pay them? And let me tell you what the answer is. Yes. Be paid. That is a shocking reality, and I want you to know about that, and we'll discuss it in just a second. But this issue of competence, there are different levels of preparation to go into court or to be a lawyer. First, you have your 3 years of law school. Then you have the state bar that you have to take. And then you practice law. Some, like Professor Hemphill, actually clerked with a judge, a federal judge, before going into private practice. Then you have what's known as board certification. Board certification means that a lawyer took another exam above the bar exam to show that he or she had particular expertise in a specific area of law. So when you ask, is the person board certified, that's only half of the inquiry. You need to ask also, board certified in what? Are you board certified in family law? Are you board certified in trial work? Are you board certified in bankruptcy? There's specific specialties. And so once you get to board certification, even though I'm board certified, I still can't represent you, I think, competently in criminal court or in bankruptcy court or in family court or in a divorce proceeding. So board certification is not enough. You need to know in what specific area. And then if I were you asking for a lawyer, you should ask the further question, how many cases have you tried if you're a trial lawyer? Have you ever done a case like the one I'm asking you about? If you've done it, what was the outcome? Were the clients pleased? Have you ever been sued on a matter such as this? Have you ever paid a claim of malpractice because of something you did wrong? Those are legitimate questions for you to ask an attorney. And if you start hearing the lawyer backing up and hesitant and so on, trust your own sense about whether this is the horse you want to ride on your very important legal matter. Professor Hemphill, do you have anything to add on that before we turn our attention to firing the lawyer?
Yeah, the best thing I can say about competence, it's not necessarily intellect either. I remember when I first started out, I had a senior partner who would always come in to the office and I'd be working real hard. And you work long hours, and he would always say, you know, Craig, the more and more time you put in, the better prepared you're going to be when you come against someone else. So, I mean, what the rules requires for you to get yourself up to speed, but also to put in time and effort to understand the service area.
And I have to tell you, some of these young lawyers that come in can really whip up on these old lions. Old lions get so tired and think that they know the law. And then these young lawyers come in and they really are getting the new versions and the new updates on the law, and they're really very talented. So don't go by age. This is not a situation where just because you're long in tooth, you're long in wisdom. This is a situation where you need a lawyer who actually has done something in the field that you need him. All right, now let's talk about show business question. Can you fire your lawyer? Well, we have to take two considerations. One is, are you on the civil side? Thank you, Jackie. I want you to know KCOH family is just wonderful. You get coffee served to you right on the radio. Thank you, Jackie. This is so nice of you. Well, I think I've got to pay for my show a little bit here. I've forgotten about my sponsor here. Let's take a break and we'll be back on Can You Fire Your Lawyer?
This is attorney Joseph Gurrier of the Gurrier Law Firm. Serious injuries deserve a serious lawyer. At the Gurrier Law Firm, we can help you navigate the twists and turns of the civil justice system to get you the recovery you deserve. Don't get lost on the sea of uncertainty. For serious injuries, call the Gurrier Law Firm, your anchor in the storm. 713-533-9077. That's 713-533-9077. Or visit us at www.gurrierlaw.com.
Call the Gurrier Law Firm, 713-533-9077. And now, let's return to the Van Hall Legal Hour.
All right, we're back, and we're discussing how to hire and fire your attorney. We're on the part now about firing the lawyer. And I think we have to kind of set this up, don't we, Professor, on one, what kind of arrangement you have with the lawyer. There are two basic types of contracts that clients enter into with attorneys. One is known as a contingent fee contract, and the other is an hourly fee contract. And you can have a hybrid of those two as well. But on a contingent fee contract, that's generally where the lawyer says, you don't have to pay me up front. But if and when you win something, we get a percentage of what we collect for you. And that's why you hear